Welcome back to the Law and Crime Network. You are my Law and Crime family, as you know, and today we have a full plate. So we are back, and I have two great guests to discuss this with, and I'd like to introduce first, because he has been on the air first, Joseph McBride. You know him well. He is a criminal defense attorney, and when I say to you, he had a brother who was wrongfully convicted, so he knows how you deal with prosecutions and defense inside out, and he also knows how justice should occur. Joseph, welcome back.
Good afternoon, Linda. It's great to be here.
And my first guest today, first time on Law and Crime Network, and it's going to take me a while here, Ikiesha Al-Shabazz.
Yes.
I am so happy you're here. I've been waiting for you for a week. You are a criminal defense attorney.
Yes.
You are a mom. I'm not going to put that in here. I'm going to put that first, even though it was last, okay? A former prosecutor. We'll kind of throw that away. An adjunct law professor, an author, Black Girl Slim.
Yes.
Okay? You have an informational platform called Ikiesha Speaks, and you also have a Twitter account. What is it?
It's Ikiesha Speaks, but I also do some bodybuilding on the side, so I have another one called Misfit Body.
Well, I'm going to talk to you about the latter one first. But first, let's
keep it legal.
Let's talk to you as a lawyer.
Yes.
So, the defense yesterday said, hey, Your Honor, we think that my guy has had a problem here of a head injury. And then it took till today a second psychiatrist brought by the defense to have the prosecution say, I think there may be a problem here. Okay, we concede.
Yeah.
What say you?
Out of an abundance of caution, the prosecution has to make sure that this person is competent to stand trial, that he's able to assist in his own defense. And he's not able to do that. From the hearing when he stood mute, and now he has the possibility of a concussion. This is not a case that you want to go forward on only to have the appellate court reverse it, and we'd be back here again trying this case again.
So Joseph McBride, I mean, Ikiesha brings up a good point. Okay, now he's going to get evaluated. I assume he's going to get an MRI. He's going to get a scan. Is there a possibility, because we all know that injury is called CTE, that he had some brain damage before, and that when he goes back, he's going to have a brain scan, and they're going to say, hey, wait a second, he's got organic brain damage, and he should not only be tried because he was incompetent, but he was crazy at the beginning, and therefore there's a not guilty issue.
There's certainly a possibility. I think it's unlikely here, but hats off to the prosecution and for the judge for handling this the right way. Here you have a case where there's a ton of evidence against this guy, and this would surely end up in an appellate litigation given the circumstances here. So what you do is you back off, you assess the situation, you let the medical examiners take over, and you go forward once he is back to being cognizant.
And Ikiesha, the judge issued those magic words, and I went to look them up again. As a matter of fact, I sent myself an email so that I would be sure to bring this up. She said manifest necessity when she said there is a mistrial. Now, what happens if there weren't manifest necessity, if she didn't use those buzzwords? What does it mean?
And obviously, the judge is making a determination that the only way we can respond to what's happening is to declare a mistrial in the interest of justice. And so her hands are tied, basically. I think it sort of gives her an out so that people understand that I had no choice but to do this.
But also, it has some legal implications, Joseph, doesn't it? I looked up a Supreme Court case, Renico versus Lett. I don't know how to pronounce it. It was in the October term, 2009. It was a 6-3 decision, and it was on the issue of manifest necessity and retrials. And there, what happened there, the judge allowed a jury to be dismissed, and then the charges were re-brought back by the prosecutor because they were hung on the first case. The defense said, hey, time out, right? Double jeopardy from the Constitution. The prosecution said, oh, no, the judge didn't give a long enough time to let the jury evaluate circumstances before issuing a hung and sending the jury home. And the defense, they went back to the Supreme Court, and the Supreme Court, because the appellate courts reversed and said, oh, no, this is a double jeopardy. So the Supreme Court came back and said, no, it's not double jeopardy because you've got to give the trial judge all the discretion in the world to do this. So manifest necessity means double jeopardy, or does that mean not double jeopardy?
Well, the Supreme Court here seems to be saying that it overcomes the idea of double jeopardy in this set of circumstances. Wise choice on the judge here to use those buzzwords.
And if she hadn't, there would be an issue of double jeopardy. As a matter of fact, it probably would have been double jeopardy because she hadn't found that unless we went to the
It's possible, but double jeopardy is this sort of fiction. Right? Because the truth is, you can be tried again. You can be tried in other jurisdictions.
6 times.
You can be tried, exactly.
And
you can be tried by the feds, right? And from a state prosecution, because they have sovereign jurisdiction. the federal government. You could walk out of state court having been acquitted and then walk right into the arms of a marshal and be charged for the same exact charges.
And Joseph, there was a case yesterday or 2 days ago where somebody, a defendant, had been tried six times over 30 years, and finally he was let go, and he's now basically exonerated because he's never been convicted 6 times. And the argument there was that the jury was being selected for racial overtones, which I'm in perfect agreement of. But 6 times he was tried. So yes, what Ikiesha said is right. It's a fiction, isn't it?
It sure is. Utter ridiculousness to be tried 6 times for something. That is just unacceptable. And I actually have a client right now where we walked him out of state court the other day, and the feds came and picked him up right there. This happens every day.
It happened. And in fact, wasn't there a case, involving the president and Manafort and some of these high-profile, whether or not there could be? Ikiesha, you're laughing. I was going to call you Ike because I know that you
can do Ike. You can do Ike.
When you bodybuild here, Ikiesha, you deserve that respect. Ikiesha, there was those cases that now people that were normally, shall we say, not for criminal defendants are saying, well, how does the feds get to try somebody a second time when the state court has acquitted them?
Yeah, the perception always changes when you're in the hot seat, right?
Okay.
Because in all of American jurisprudence, it's always been okay for there to be a secret investigation. That's what all the grand juries are. They're secret investigation. And how many times have you seen a complaint? How many times have you seen a complaint that said the person known to the district attorney's office, right?
Yeah.
You don't get to know all the time who the witnesses are against you, not in an investigate, but soon as it's the president, well, this is done in secrecy. This is wrong.
Okay.
We want to know.
Okay,
right?
so I'm going to move it off politics, but I'm going to move it into politics.
Right.
Does this give the impetus for something like this case, for instance, if it comes back that turns out he has organic brain damage, not just in like one area that he fell in, but all over his brain, give impetus for the fact that maybe there should be some reform in the criminal justice system to deal with inmates who are mentally ill? Joseph.
Oh, absolutely. The 2 things that are routinely criminalized in the criminal justice system are poverty and mental illness. Neither of them should be subject to criminal implications. Both of them are in need of great and deep reform.
Yeah, but then I look back at it with the both of you and I say, well, here, you had Derek Archie, he was 31, Haley Stone, she was 20, Xavier Green, 28. They died. And for their families, it doesn't matter whether Whitehead was crazy, whether Whitehead's a nut job, whether Whitehead didn't have treatment. The families of these people had 3 deaths, and the victims are going to suffer no matter what. Ikiesha.
Maybe this is the type of case where we look at whether restorative justice is something that could be helpful, because nothing will bring these people back. But maybe if they had an opportunity to understand what's going on with this young man, right, and participate in his prosecution in some way, that could be cathartic in some way, right? That's what we're trying to move towards too, right? A more humane justice system.
We hope.
But what if he's malingering?
Ikiesha, that gives me to let me go to Joseph. Your brother was convicted.
Yes,
right?
he was.
And when Ikiesha talks about the buzzwords, more humane criminal justice system, she's also talking about people who are wrongfully convicted, because for every wrongful conviction, there is a crazy lunatic, a defendant, and I won't say crazy, there is a guilty person out there free.
That's correct.
Yeah.
And it makes you scratch your head, it makes you wonder, and having gone through it firsthand and watching the effects that it not only has on the victim, the person who's been wrongfully convicted, because in a wrongful conviction there's 2 victims. There's a victim of crime and there's a victim of the criminal justice system. It's wrong. The effects are catastrophic. They last a lifetime, and it's really hard to wrap your head around.
And you know what? That's why we have the Law&Crime Network here. That's why our founder, Dan Abrams, said we have to be fair for both sides, and we try to bring you both sides here at the Law&Crime Network, which we will do after this break.